Good day, students, and welcome to our third narration on acquisitive prescription as a mode for the original acquisition of ownership. In our first presentation, we focused on some introductory remarks as well as the rationale for acquisitive prescription, and in our second narration, we focused on the requirement of control. So in this narration, we will focus on the interruption of the running of acquisitive prescription, as well as the postponement of the running of acquisitive prescription. Okay, so for purposes of interruption, I kindly draw your attention to pages 125 to 126 of your prescribed textbook. When we talk about interruption, it is important to remember that there are two kinds of interruption, or two kinds of ways in which the running of acquisitive prescription can be interrupted. The first is natural interruption, and the second one is judicial or civil interruption, which we will discuss on the next slide. However, for both kinds of interruption, it is important to remember that there is a very important distinction between the interruption that happens or how it is regulated in the 1943 Prescription Act versus how it is regulated in the 1969 Prescription Act. This distinction is important for those prescriptive periods that run over both application times for the respective acquisitive prescription periods. So this is why you must remember how the natural and civil interruption is regulated in the different acts, because if the prescription period runs for a very long period of time that coincides with the application of these both these statutory provisions, you must consider how this interruption is regulated differently. So let's look at how natural interruption occurs in terms of the 1943 Act. So in terms of the 1943 Act, you can interrupt the running of acquisitive prescription if you, as unlawful possessor, voluntarily give up or surrender your physical control. If you voluntarily give up or surrender your physical control. It is also possible, in the alternative, to involuntarily give up your physical control, and this is when that physical control is physically or forcibly taken away from you as the unlawful possessor. Now, this can be done by the owner, him, her, or themselves, another person, or through a vis maior, which is a great or superior force. Now, it's important in this conception of involuntary natural interruption in terms of the 1943 Act to remember that the owner cannot merely protest to your unlawful control. That would not be enough to naturally interrupt the running of acquisitive prescription. They have to physically and forcibly take away your effective control. Now, this is different in the 1969 Act. Well, at least the involuntary part is different. So it's still possible to surrender voluntarily or give up your effective physical control in terms of the 1969 Act. So this is same for the 1969 and the 1943 Act to naturally interrupt the running of acquisitive prescription. However, it is different for the running of or the involuntary interruption natural interruption of the running of acquisitive prescription. And so here, in terms of the 1969 Act, there's an exception to the normal principles, which says that if you have lost or surrendered involuntarily your physical control, given that the owner has taken it away from you, it is possible for you to regain your effective physical control through a lawful manner, and this is typically through the mandement van spoelie, within 6 months. And if you are able to regain the physical control which you lost within 6 months through the mandement van spoelie, the natural interruption would not have occurred, and the acquisitive prescription will continue to run as if nothing happened. An alternative to this, in terms of the Prescription Act of 1969, is that if you are able to, in another lawful way, other than the mandement van spoelie, to regain effective physical control lawfully of the land or the property that you are unlawfully possessing within 1 year, you can also regain your control of that land, and the natural interruption would not have occurred. In other words, the running of acquisitive prescription will proceed as if nothing happened. And this second alternative is typically when, after a vis major, after a great force or a superior force, like a natural disaster, happened, and the land is, for example, perhaps just lying there unoccupied, and you simply go back and unlawfully possess the land. It would be possible for you to regain your control and for natural interruption not to have occurred at all, and acquisitive prescription to just continue running as if nothing happened. Okay, so in addition, or as an alternative to the interruption of the running of acquisitive prescription in a natural way, it is also possible for the running of acquisitive prescription to be interrupted in a civil or a judicial way. As was stated on the previous slide, the distinction, or there is a different regulatory framework for the interruption or civil or judicial interruption of the running of acquisitive prescription in terms of the 1943 and the 1969 Act. So let's look at the 1943 Act. So first and foremost, it is possible for the running of acquisitive prescription to be civilly or judicially interrupted if the unlawful possessor simply acknowledges the stronger right of the owner. And this is regulated carefully by Section 61A of the Act, which lists 4 kinds of examples where this kind of acknowledgement can occur, and I strongly advise you to go have a look at that. In addition to this acknowledgement, it is also possible for the running of acquisitive prescription to be civilly or judicially interrupted through the service of process, and this is regulated by sections 61B to D of the Act, and I encourage you to go and have a look at that for yourself. And so this is a very unique way where you can see how there is a synergy between property law, or the law of things, and your modules on civil procedure. All right. However, when this service of process happens, it must be done in a very particular way, in that the owner must not only claim his, her, or its stronger right to ownership, but it must be stated very clearly that this claim is based on ownership. So ownership must be asserted as a trumping ground to stop the running of acquisitive prescription. So very important that in this assertion of ownership, it is not enough for the owner to merely claim that rent is due, or claim that compensation is due to be paid for the unlawful possession of the property, because in the service of process documents, that would not be enough. In the acknowledgement, that would be enough for the unlawful possessor to offer to pay rent or offer to pay compensation, because that would acknowledge the stronger right. But if the owner is instigating the process through the service of process, he, she, or they cannot merely claim that. They must firmly state and assert that this claim is based on ownership. All right, let's move on to the 1969 Act, and there the process is regulated similarly, in that you can civilly or judicially interrupt the running of acquisitive prescription through the service of process documents. And so this is regulated carefully by section 4.1 of the Act. And so we can see there that there is a host of documents that would satisfy this service of process claim. However, it is important to remember that this is the regulation of civil or judicial interruption of acquisitive prescription is slightly more refined, in that it is possible for your claim based on ownership that you've asserted now based on the service of process documents to lapse when in the following circumstances: when you do not prosecute that claim until you get a judgment, or if you abandon your claim at some point in time before a judgment is rendered, or finally, if a judgment is received or handed down, but that judgment is then set aside on appeal. So all of those instances would make it possible for civil interruption to lapse in terms of section 4.2 of the Act. However, if none of this happens and the service of process proceeds and civilly or judicially interrupts the running of acquisitive prescription, section 4.3 makes it plain that a new prescription period will start to run afresh or anew. So even if acquisitive prescription happened to run for 20 years and was then civilly or judicially interrupted, that period will start from day one or from zero again. Okay, so in addition to interruption, either naturally or civilly, it is also possible for the running of acquisitive prescription to be postponed. And so here I draw your attention to pages 127 to 128 of your prescribed textbook. Okay, so by way of introduction to postponement, the core founding principle for postponement as a way of interfering with the running of acquisitive prescription is this. It's the contra non valentem agere non currit praescriptio principle. Now, translated, that means quite simply that prescription cannot run against people who are unable to look after their own affairs. I think that is a sound principle, and we see that manifest not only in property law, but in different areas of the law. So this is why the following kinds of people have been identified as particularly vulnerable and where this principle applies. So we see that acquisitive prescription cannot run against minors. And so here there is a concrete link between property law and the law of persons. Acquisitive prescription can also not run against people who are suffering from some sort of mental incapacity. So again, a link between property law, the law of persons, perhaps even the law of contract, where contracting capacity were discussed with you. Acquisitive prescription can also not run against the person that have been placed under curatorship. So again, reference to law of persons, a reference to law of contract. And then the following one, the fourth one, is an interesting one, in that acquisitive prescription can also not run against persons who were absent from the land because of service to the state or by reason of war. So here it could be that someone's service to the state could be because they are a politician or because they are in the diplomatic service, and then by reason of war it could be that this person is a member of the armed forces, either the army or the military of some sort, the air force, perhaps even the police force of some sort, or some intelligence agencies or secret agencies that protect national interests. If they are away from their land or from their property because of these reasons, it would be impossible for acquisitive prescription to run against them, and then that postponement would be applicable. It is furthermore possible for postponement to be implicated for a married woman that is still to this day subject to her husband's marital power. That was an issue historically, but because of the running of acquisitive prescription, it would be possible that, or it is still possible that we think about this gender dimension, where in days gone past, in years gone past, married women were subject still to her husband's marital power. Second to last issue here is where a fideicommissionary is pending the fulfillment of the condition in the fideicommission in instances where the fideicommissionary property was alienated by a fiduciaris who did not have the power to do so. So this is where the last person in line to gain a benefit from this fideicommissionary or fideicommission rather, suffers some prejudice because the person immediately preceding them, the fiduciaris, acted in a way as it pertains to the property from which a benefit should be generated in an illegal way. And then finally, sort of a catchphrase or last kind of safety net is where a person would otherwise have been prevented from enforcing their rights. So that would also make it impossible for prescription to run and for postponement to take place. Okay, so let's look then at how postponement is regulated, and you will see from the slide that as with natural and civil interruption of the running of acquisitive prescription, postponement is also regulated differently, in fact quite remarkably different, in the 1943 and the 1969 Act. So the 1943 Act is rather simple in its regulation, because it says that prescription does not run at all when this impediment exists, while this person is unable to take care of their own affairs. So it is simply not possible for acquisitive prescription to run at all during that period of time. But however, the moment that acquisitive prescription, that impediment falls away, acquisitive prescription would continue, importantly, for the remainder of the 30 years once that impediment falls away. So that was really simple. I mean, for example, if acquisitive prescription started to run in 1990 and impediment set in 2000, so after 10 years of acquisitive prescription to started running, and that impediment lasts for 10 years until 2010, and then falls away, acquisitive prescription would then start to run again in 2010, but for the remainder of the 30 years, so for another 20 years. Okay, it's a very simple sum to do, basic numeracy skills. However, in terms of the 1969 Act, it is regulated slightly differently. So here goes. This regulation we find in Section 3 of the Prescription Act of 1969. And so the first difference that the 1969 Act makes is that it draws a distinction between the kinds of persons we identified on the previous slide. So instead of grouping them together in one go, the 1969 Act distinguishes between them, still uses the same people, but distinguishes them as persons against whom prescription is running and persons in whose favor prescription is running. So in the first category, the persons against whom prescription is running, the following people are identified, and I'm quoting from the Act here now. So a minor, or if that person is insane, or is a person under curatorship, or is prevented by superior force from interrupting the running of prescription. Okay, so 4 kinds of people: a minor, an insane person, or a person with mental capability problems, a person under curatorship, or a person that is prevented by superior force from interrupting the running of prescription. Then, in the second category, persons in whose favor prescription is running is regulated by Section 3(1)(b). And again, I'm quoting from the Act, is prescription is running is outside the Republic. So this is again those diplomats or security forces people. Is married to the person against whom the prescription is running, in the second place, or is a member of a governing body of a juristic person against whom the prescription is running, in the third place. And then we skip to Section 3(2) of the Act, where the fideicomissum is included. So 4 categories of people that is included again there. Now, the more sophisticated regulation in the 1969 Act is then regulated in Section 3(1)(c), where it says we have to keep in mind the running of prescription. Take that 30 years, and then we say if the impediment falls away before, my apologies, if the acquisitive prescription period would have terminated before, on, or within 3 years after the impediment falling away. Okay, so again, let's just make sure we understand that. If the period, the 30-year continuous uninterrupted period for the running of acquisitive prescription would have terminated before, on, or within 3 years of the impediment, which we talked about on the previous slide, falling away, happens, then we add automatically another 3 years as a safety mechanism for the running of acquisitive prescription. So it effectively means that acquisitive prescription would have to run for, in some instances, 33 years, but especially in the case where acquisitive prescription ends before the impediment falls away, that could be for many more years than the initial 30 years that is anticipated as a standard rule for acquisitive prescription to run. And this is the single most difficult thing about acquisitive prescription, is this regulation of postponement. So I strongly encourage you to make sure you understand how this works, and there is a useful example about how postponement works in the context of a minor. So, and this appears on page 128 of your prescribed textbook. So I strongly encourage you to have a look at that.